How to separate property become marital property in New York. When couples decide to tie the knot, they often bring their own assets and properties into the marriage. In the state of New York, these pre-existing assets are typically classified as separate property. However, as the marriage progresses, certain factors can lead to the transformation of separate property into marital property, creating complexities in the event of a divorce. Understanding the process by which separate property can become marital property is crucial for individuals navigating the legal landscape of divorce in New York. Definition of separate property. In the state of New York, separate property refers to any asset or property that a spouse owns individually outside the bounds of marriage. Separate property can include property acquired before marriage, gifts or inheritances obtained during the marriage, provided they are addressed to only one spouse, compensation acquired for personal injuries sustained by a spouse, except lost wages or medical bills, property acquired in exchange for separate property, and any increase in value of the separate property, unless the increase is due to the efforts of the other spouse. Definitions of marital property. Marital property, also known as marital estate, refers to all assets or property acquired by either spouse during the course of a marriage. New York is an equitable distribution state, which means that marital property is divided equitably, but not always equally, after considering various factors in the event of a divorce. Classification of separate property. In the realm of marital and family law, property is typically classified into two main categories: separate and marital property. Separate property, also known as non-marital property, is not subject to division upon divorce and is solely owned by one spouse without contribution from the other. Spouses need to understand the different classifications of separate property, as the identification and proper categorization of these assets can play a pivotal role during divorce proceedings and the division of marital property. Separate property acquired before the marriage. One of the most common types of separate property is that which was acquired by one spouse prior to the marriage. This can include real estate, bank accounts, investments, and personal belongings such as cars, furniture, and collectibles. As long as these assets are not commingled with marital property during the marriage, they are typically considered separate property and are not subject to division upon divorce. Inheritances and gifts to one spouse. Another classification of separate property includes inheritances and gifts received by one spouse, either before or during the marriage. As long as the inheritance or gift is not commingled with marital property and remains in that spouse's name, it is generally considered separate property. Examples of inheritances and gifts can include cash, property, or other valuable items that are given to one spouse. Personal injury compensation. Personal injury compensation that is awarded to one spouse for pain and suffering, disability, or disfigurement is generally considered separate property. This is because these types of damages are intended to compensate the injured spouse, not the marital unit as a whole. Property acquired through a trust or prenuptial agreement. Another type of separate property includes assets acquired through a trust or pursuant to the terms of a prenuptial agreement. Trusts are legal arrangements where property is managed by a third party, known as a trustee, for the benefit of designated beneficiaries. Property held in a trust for the benefit of one spouse and not the other is generally considered separate property. Ways separate property can become marital property. In the context of marriage or divorce, it is essential to understand the difference between separate property and marital property. Separate property generally includes assets acquired before the marriage, inheritances, and gifts received solely by one spouse. On the other hand, marital property consists of all assets acquired by either spouse during the marriage, irrelevant to the name on the title. However, there are ways in which separate property can become marital property, intentionally or inadvertently. Transmutation of separate properties. Transmutation involves the conversion of an individual asset into marital property. In New York, this occurs when a spouse deposits their personal funds into a joint account shared with their partner, which has survivorship rights. As a result, the money undergoes transmutation and becomes a shared marital asset. Commingling of separate properties. Commingling precedes transmutation and involves the mixing of separate property funds into a joint marital account. It is important to note that commingling does not automatically alter the ownership of the funds. The actual act of transferring the funds is referred to as commingling. On the other hand, transmutation takes place when there is an intention to convert the asset into marital property. Seeking legal assistance in New York divorce proceedings. Divorce is a difficult and emotional process for all parties involved. It is often complicated by the numerous legal issues that must be resolved during the process. In New York, divorce proceedings involve multiple steps, including filing a summons and complaint, exchanging financial information, negotiating a settlement, and potentially going to trial. A skilled divorce attorney can help guide you through this challenging process and help you achieve the best possible outcome for your case. Consultation and representation in property division. Property division is often one of the most challenging aspects of divorce, as both parties may have strong emotional attachments to their possessions. However, equitable distribution of marital assets is required by New York law. During the initial consultation with your attorney, it is essential to discuss your assets and debts, as well as your preferences for property division. Your attorney will help you understand the legal concept of equitable distribution and how it applies to your case. They will also guide you on what factors the court considers when dividing property, such as the length of the marriage, the financial contributions of both parties, and the value of the assets. At New York Family Law Group, our Manhattan divorce lawyers may be able to play a pivotal role in protecting your interests and advocating for a favorable outcome. Our team may be able to guide you through the legal intricacies, ensuring that your separate property rights are preserved and that you receive an equitable distribution of marital assets. Contact us today at 347-212-5113 to schedule a consultation.